Many people, when I speak to them about limited scope representation, have concerns about the ethics. So it was clear that I was going to bring in an expert on ethics to talk to you about limited scope representation, to make it clear, to make it easy. And I can't think of a better person to talk to you today than our speaker, Carte Lachter, who is an attorney who works for Hinshaw and Culbertson. She's a partner there. And she is also an adjunct professor at, I believe, Columbia Law School. And I have to say that whenever I need someone to teach our volunteers about ethics, Katie's always willing to do so, because we depend on ethics. I mean, we depend on, volunteers to do our training. And we don't pay at all. We don't even feed them half the time. And so Katie is one of our willing members of the Army, the Access to Justice Program Army. Carte Lachter will speak to you today about the ethics of limited scope representation. You can sit me on stage. Okay.
Hope you all will forgive me for sitting. I'm dealing with a herniated disc, but first I want to say thank you to Judge Fisher for that very kind introduction. I can't think of an Army that I would rather be a member of than this one. And as she mentioned, for the last several years, is this on? Are we good? Okay. I want the one that says HON in front of my name. It's as close as I'm ever going to get. That would be unethical. Thank you for pointing that out. For the last several years, I've taught the ethics training for the Volunteer Lawyer for the Day program, and some of the best and most interesting questions that I've gotten from audience members have come from those audiences. So I'm hoping this will be somewhat interactive. I feel bad for the folks in Albany who can't really interact, but anyone in the room here, feel free, if you have a question, jump in while I'm speaking, and we'll also have some time at the end for questions. But I think the potential benefits of limited scope representation are pretty well documented. And the last thing that we want to see happen is the people who take their time and are generous enough to want to provide service, pro bono, to low and moderate income people to fall into ethical traps that they didn't mean to find themselves in. And it is absolutely possible to ethically represent clients as lawyers on a limited scope basis. And there are also a couple of potential pitfalls that I want to raise for you so that we can discuss them, and then you can avoid them and not have to worry about that going forward. So there actually is an explicit endorsement in the rules of professional conduct for limited scope representation. There are two rules that you want to start with if you're going to undertake this kind of representation. The first one is Rule 6.5, which specifically has to do with participation in what are called limited pro bono legal services programs. And I should point out, and we'll come back to this, that limited scope representation does not necessarily mean pro bono. It's possible to have a paying representation as well, where you agree with the client in advance to limit the scope and receive a certain payment for what you're going to do, and lay out for the client what you're not going to do. And so I'll talk a little bit at the end about how that works. But Rule 6.5 is specifically about pro bono representations and particular kinds of pro bono representations. So it allows lawyers to provide short-term limited legal services, which is a defined term in the rule, to clients in programs sponsored by courts, bar associations, or nonprofits. So the Volunteer Lawyer for the Day program is a good example of something that would fall under Rule 6.5. The definition in the rule of this short-term limited legal services program involves providing legal advice or representation free of charge with no expectation that the assistance will continue beyond what is necessary to complete an initial consultation, representation, or court appearance. So it's specifically limited in duration as well as in the scope of what a lawyer can actually do competently within that time period. The thing about Rule 6.5 that's helpful to know, the major thing, is that it relaxes the rules relating to conflicts of interest so that private practitioners can engage in these kinds of limited scope representations without having to go back to their law firms and run conflicts on these limited representations and make sure that their firm doesn't have an issue. So normally, and you'll hear people say this a lot, the same ethics rules apply when you're representing somebody pro bono or when you're representing a paying client. Same rules apply when you are representing somebody in a limited scope or when you're representing them in a full representation. And the only caveat to that is that Rule 6.5 does relax the conflicts rules and makes it so that lawyers only have to be concerned about conflicts that they have actual knowledge of. So if you show up at a volunteer lawyer for the day program and the first client that's assigned to you, you happen to know you're working on the other side of a transaction from that person, then you have to flag that. Or if you happen to know that somebody in your law firm is adverse or potentially adverse to that client, you have to flag that. But otherwise, if you don't have any knowledge or any reason to think that there's a problem, you can go ahead with the representation without worrying. So the first thing you want to do if you're going to volunteer under a program is talk to the program coordinators and just make sure that the program meets the requirements of Rule 6.5, which the program administrators should know and should be able to tell you. And then that gives you guidance. The other rule that you can look to is Rule 1.2, which generally has to do with the scope of representation and the allocation of authority between the client and the lawyer. And it generally lays out the decisions that clients get to make and the ones that lawyers get to make. Specifically, subsection C of that rule says that a lawyer may limit the scope of the representation if the limitation is reasonable under the circumstances, the client gives informed consent, and where necessary, notice is provided to the tribunal and/or opposing counsel. I understand that you're having a whole program later today on ghostwriting. That's the issue that tends to implicate that where necessary, notice is provided to the tribunal clause, because there's a concern about courts potentially giving preference to pro se litigants not realizing that they're actually represented by counsel. So I'm not going to spend time on that because I know you're going to have a whole session on it later. But where I am going to focus actually is on limitations being reasonable under the circumstances, how you make that determination, how you communicate that to your client. So unbundling legal services is ethically permissible, huge potential to address unmet legal needs. But some of you might be thinking, this is a departure from like the optimal, full, first-class representation that you normally give your clients. It's that aspect of it, I think, that implicates ethical concerns. And I'm going to point out the two that I think are the biggest pitfalls, and then if anyone has additional concerns, we can look at those. But for me, I think the duty of competence, how do you competently provide representation to a client when you're limiting from the outset what you're able to do for that client? And how do you deal with things that come up in the course of the representation that may not have been so apparent to you at the outset when you agreed on what the scope of your representation was going to be? And the kind of glib answer to that is that it always comes back to the lawyer. It's the lawyer's job, not the client's, to figure out what's reasonable under the circumstances. It's the lawyer's job, not the client's, to flag potential difficulties as they arise. So for competence, which I think of as chief among the rules of professional conduct, it's Rule 1.1. It's easy to find. Any interaction with a client, even if it's limited in scope or very short in time, or even if it's not a full client, even if it's just a potential client, prospective client, that raises triggers duties on the part of the lawyer. Obvious statement, but I'm going to make it anyway just because I feel like I have to. The fact that the attorney is not providing full legal representation to a client does not relieve the attorney from acting competently. I once had someone who I think was a jokester ask if you can contract around the competence rule. can you say to a client, I'm providing you a limited scope representation, and my representation may or may not rise to the level of competence as required by the rules? That got a laugh and a resounding no, and I'm about 90% confident that the person was kidding. I would argue, actually, that competence may even be more important in situations where you're not undertaking a full representation, because you don't have the same opportunity with a client that you're representing for a day to follow up on any potential issues, correct a misstatement that you might have made, or you realize that maybe your client misunderstood something and you don't have the opportunity to call them up. So it's actually even more important to know the boundaries of what you are and are not able to do in these kinds of representations. The comments, if you're interested in reading a little more about this, the comments to the rules are really helpful. And the comment to Rule 1.2 explicitly links the duty of competence to the requirement that any limitation on the scope of the services be reasonable. So just by way of example, if a client just wants to get some general information about the law surrounding a common, uncomplicated legal problem, the client might agree that the lawyer's representation will be limited to a brief telephone consultation. In the abstract, that's probably fine. That limitation would not be reasonable if the time allotted is not sufficient for the lawyer to actually impart to the client all of the information that the client needs to get a full picture of the situation. So part of the duty of competence is determining whether a potential limitation or a potential unbundling is reasonable under the circumstances. Some of these are routine. They don't generally present any problem. A lawyer can represent a client at trial, but not on appeal. That doesn't usually raise an issue. A lawyer can draft a will for a client, and it's not going to be expected that that lawyer is also going to litigate a family law claim on behalf of the client. In other situations, the reasonableness of the proposed limitation may be less clear. So I want to talk about this by way of a case, because I always think it just works better when you put things in context. So there's a case, because it's a family law case, it's just initials, MC versus GC, where a very large law firm, which rhymes with Baden, had a relationship with a nonprofit that provided family law services to indigent clients, so divorces and custody issues. And specifically, the nonprofit associated with the law firm to provide help on uncontested divorces. So this was supposed to be a way for associates in the law firm to get some experience, help clients who needed it in relatively uncomplicated matters. Uncontested divorces involve paperwork and some negotiations, but generally not litigation. So there was an associate at the firm who gets assigned to the case through this program. She's a mid-level associate. She had no prior experience handling divorce cases, and she was told by the nonprofit that the assistance she would be providing would be limited to this uncontested divorce. And so the associate, through this program, begins representing the wife. And in one of their early meetings, the wife asked the attorney about the possibility of obtaining a custody order that would allow her to relocate out of state with her child. And the attorney's response was that she couldn't help with that issue. And the attorney, I think, legitimately attempted to explain, what she saw as the limited scope of her representation. So I'm going to read you what she said to her client. She said, "Please be advised that I was not retained for a contested divorce, nor was I retained to advise you regarding relocation. Rather, you originally retained me as pro bono counsel for an uncontested divorce, based on the facts that you initially presented to the nonprofit. As such, if settlement negotiations break down over an unreasonable disagreement as to visitation rights, I will withdraw my representation. Furthermore, I will not negotiate the relocation issue under any circumstances. While I am well aware of your desire to move to Florida in the near future, I do not have the experience or the time to handle a lengthy relocation trial." So what do you all think about that client communication as a way to give the client a sense of what the parameters of the representation were? Anyone? So if you don't volunteer, I have to call on Judge Fisher's son, and that's just really not nice. Okay, I see a hand over here.
It would have been nice if that had been spelled out in advance of the lawyer representing his client. And look, I'm protecting the lawyer, okay, there's no custody stuff. That's not part of what I'm here for.
Yeah, that's sort of point number one, right? If you're going to limit the scope of the representation in that way, you have to spell it out in advance what that means for the client. Client may think, okay, yeah, I want an uncontested divorce, but that doesn't necessarily mean that the person she's negotiating against is going to give in on everything that she wants. So it may not be realistic that this divorce is going to be uncontested. So that's the kind of thing where you can't just say to the client, okay, I'm here to represent you in an uncontested divorce. You actually got to explain to the client what that means. And if the firm and the nonprofit had done that in advance, they wouldn't have found themselves in this situation where they're representing someone and all of a sudden this limitation is not looking so reasonable. Yeah?
I also think that it may have really tried to give the client a sense that there are options other than relying on me, rather than I'm not doing this, period, tough luck, that, some explanation of this is what you might think about.
Right. I mean, for anyone who didn't hear that comment, the idea is that you want to give your client options other than just potentially relying on this one lawyer who's volunteering. Instead of saying, I won't do this and I won't do that, she could have said, this is not something that I could handle, but maybe there's someone else who'd be able to help you and I can help you find someone. Or here are the options for if you want to handle it this way versus that way. But what do you think was the ultimate result of that kind of communication to this client? Anyone want to guess what the client does? No, that's so interesting. See, the client didn't realize that there was anything wrong with these statements. No, the client didn't call the disciplinary committee. The client didn't file a grievance. The client signed a stipulation of settlement. These comments, if you don't settle, I'm going to withdraw from representing you, and if I won't negotiate X or Y, led to the client feeling like undue pressure to just settle the case when it turns out there actually were contested issues. So the wife goes ahead and signs a stipulation of settlement. The stipulation provides that she can't relocate, which is a standard term in an uncontested settlement statement, and it also waived her right to equitable distribution. And there was no discussion between the attorney at the firm and the client about the financial consequences of just settling her proceeding. Now, the attorney was apparently under the impression that her client could modify the terms of the stipulation at a later date, but that turned out to be incorrect. So on top of this, we have the problem of having given just incorrect legal advice. And so eventually the wife realizes that she doesn't want to be bound by this document. She got new counsel, and she moved to vacate the stipulation and wanted to litigate the relocation and the equitable distribution issues. And the wife got lucky because the court saw what happened here and was actually highly critical of the associate, as well as the law firm and the nonprofit organization. The court found that the attorney lacked appropriate training, supervision, and oversight, and that as a result, she made material misstatements to the wife and put improper pressure on her to settle.
So is there a recommended retainer statement that a unbundled lawyer is going to be given before he or she sticks their neck out?
So the question is,
everybody on their own.
Right. The question is there some kind of form retainer statement that a lawyer who's going to engage in unbundled services is going to be given, or is everyone on their own? A lot of, and I'd venture to say most, if not all, of the organizations under 6.5 are going to have standard statements that their volunteers enter into with clients, so that it's clear what the parameters of the representation are.
And within your materials, there are some sample limited scope retainers. that you can look at.
Right, and that's the other thing. There are a lot of, there's not like one form that every law firm uses when it works with a nonprofit, but it's a good idea to either look at the samples or for a firm to create one based on the circumstances of the particular representation. I mean, one of the problems is that all these representations are going to be different. And so as the lawyer, before you take this on, you want to really think about, what's this representation going to look like, and what's likely to come up, or what's potentially going to come up down the road that might change this. So one of the things I always find really helpful in retainer agreements generally is saying to the clients, if you are to decide that you want to litigate certain issues relating to your divorce, I can't represent you, in that litigation, but can refer you to, X or Y. Just so the client understands that there are options there and that, she's not stuck. What this attorney did was try to fit a square peg into a round hole. She tried to make a divorce that wasn't really uncontested fit into the model of the uncontested divorce situation. And I think, a lot of that comes from the attorney not having a lot of experience herself with probably representing her own clients. As a third or fourth year associate in a huge law firm, may not have even had direct client contact yet. So there were a lot of factors here that led to that situation that I don't think will affect most attorneys who are going to be taking on these kind of representations. Yeah?
It strikes me that this gets back to a very common law practice problem that is honored more in breach than the observance, which is doing good intake and screening interviews.
Yeah.
And it
Absolutely.
makes me wonder whether nonprofits that are going to make these sorts of referrals, that one of the types of pro bono services offered is a lawyer in that area of practice, Tuesday night's your matrimonial night, hypothetically, and we're going to have someone, matrimonial lawyer there who does not take these clients on, but does a detailed screening interview, so that this question of, I would like to do this thing that is out of the ordinary for an uncontested divorce, that you screen that person out early, and you don't leave it in the hands of some M&A associate, to know what the right questions are on the first interview.
Right.
I mean, I'm not trying to let the lawyer off the hook, but it seems to me that a lot of the issue comes from people actually listening to their clients on the way in the door and making sure that they know what their client's goals are of the transaction all around the issue.
Yeah, I mean, I can't disagree with that statement in the least. I mean, and even for paid representations, doing good intake, making sure that you're taking on a client where you are competent to handle their work, that you're not getting yourself into work that you don't want to be doing for whatever reason. I mean, that's sort of a universal goal, and that could have short-circuited a lot of the problems that happened in this case. Yeah.
And that example you gave,
Yes.
would it have been better if the attorney withdraw and not also sign this?
So that's a great question. The question is, would it have been better for the attorney to withdraw instead of making that statement that kind of forced her client into signing the stipulation? Complicated answer to that question. The attorney may or may not be able to withdraw at that point in the representation. Withdrawal is governed by Rule 1.16. Clients can fire lawyers at any time for any reason. Lawyers have to withdraw consistent with their obligations under the rules of professional conduct. At that point in the representation, if it would have prejudiced the wife to have her attorney simply withdraw, the lawyer may not be able to just get out, particularly since the understanding in Rule 1.2 is that you can limit the scope of your representation, but it has to be reasonable. And at that point where they were, the limitation may not have been reasonable anymore to only work on an uncontested divorce when it became clear that the divorce was contested. Yes?
Can I ask a
Yes,
question?
Judge Fisher?
Was there also a problem with informed consent in that scenario as well?
Yes, absolutely. So the other piece of 1.2c is that the client has to give informed consent to the limited scope representation. And if all that was done was put a form in front of this client that said, I'll represent you in your uncontested divorce, but didn't explain to the client what alternatives were to limited scope representation, or what an uncontested divorce actually meant, or what the lawyer wasn't going to do, then there's a consent problem as well. So my colleague at Columbia wrote an article about this case, and his view is that the lawyer could not withdraw at that point. Once you agree to take that client on, and it becomes obvious that the limitation you initially had in place isn't going to work anymore, then it's your obligation to represent that client. And that could mean, though, if a firm like Baden wasn't equipped to litigate a divorce case, which many of those law firms would not be. That's one area where the big firm probably doesn't have a competent attorney. They could work with the nonprofit. I mean, this is a joint representation with a not-for-profit. They could go back to the not-for-profit and say, this isn't really working. Can we find a family law practitioner to represent this person? But they had an obligation to do something other than just withdraw, and certainly not threatening the client with withdrawal if she didn't do what the lawyer was saying, she'd been retained to do. Yeah.
Did you say she had the term, she wouldn't represent her, or she would only represent her in a reasonable custody dispute or unreasonable?
She did make a comment in her advice to the wife. She said, if settlement negotiations break down over an unreasonable disagreement as to visitation rights, I will withdraw my representation.
Especially from the point of view of informed consent. What does that mean
Right.
for a layperson, and especially an unsophisticated person?
Right, I don't know what that
For the
means.
Albany people, will you repeat the question?
Yes, yeah, the very good question was, this line in the attorney's advice to the client about, if settlement negotiations break down over an unreasonable disagreement as to visitation, I will withdraw my representation. What do you do with that from an informed consent perspective? What does that even mean? And what if this is a relatively unsophisticated client? I mean, I don't know what that means, to be honest. What's an unreasonable... You're talking about visitation of your kids. It seems to me that just about everything you're feeling there is going to be reasonable. So that was just another example of not good communication on the part of the attorney with that client. And I think what she was trying to say was that I haven't been retained to negotiate visitation issues because I was told that this was going to be uncontested, and that's not uncontested. But again, there's a major communication breakdown there on top of the fact that, once the lawyer caught on, I assume she caught on that this didn't really feel like an uncontested situation anymore. What she needed to do was change her approach and her advice, not try to get the client to, change what she needed from her divorce. So, yeah.
What I see as a potential pitfall is that long ago, in terms of when I first started doing legal services work, some of the advice from older practitioners was something is better than nothing. The client is going to be better with you than without you. And philosophically, I grappled with that in terms of the full representation model and what poor people may just get
Right.
versus what is really optimal. And so sometimes I see where the managed expectations, that piece is not there on either side of the path. Because I typically see limited scope as more rushed, quicker, not fully kind of fleshing out all the issues, because we tend to see certain areas of the law which might fit limited scope better, but yet we know that the complexity within hearing somebody's life story about a situation is going to change. So when I see this scenario, I'm sympathetic to a practitioner because often you get newer and younger practitioners trying to get experience, or someone trying to get experience in an area that they're not familiar. You don't necessarily see a lot of support, and you see everybody in terms of even the client, well, something's better than nothing. I need some help because otherwise I will be by myself.
Okay, I'm going to...
Some of those things I see in this scenario.
And I think that's a concern on a number of people's minds today. I'm going to ask Katie to address it from an ethics viewpoint, and our next panel will talk about the practical aspects and the policy implications that you're raising, Judge Saunders, which is a very valuable discussion to have, and we have plenty of time to have it for the next panel. Why don't you address that from an ethics viewpoint?
Yeah, I mean, what I would say in response to that is, here's a perfect example of this case, of a situation where the client probably would have been better off proceeding pro se and just raising her custody and visitation issues with a court instead of having to move to vacate a settlement. I mean, getting a court to vacate an order when the litigant was represented by counsel in entering into that agreement, certainly not a sure thing. And that's why I said, this was a New York Supreme Court case. I'm forgetting now who the judge was, but I'm saying this wife actually got lucky because I could easily envision a situation where the court would say, you know, you had counsel and you signed that document.
I believe it was Judge Gesmer, but
I think you're right,
Judge
actually.
Gesmer,
That sounds right.
who was a matrimonial judge.
Right. So there was a thoughtful judge who made a thoughtful decision there. But Judge Fisher, do I have time to address one other
issue?
Okay. The other thing I wanted to point out, which has to do with both paid and pro bono limited scope representations, is that the question of whether you have an attorney-client relationship, some kind of ongoing attorney-client relationship, can also come back to bite well-meaning lawyers if they're not careful about it. So it's very possible to limit the scope of your representation so that you don't have that kind of ongoing relationship. An ongoing lawyer-client relationship comes with a lot of duties on the part of the lawyer, you know, confidentiality, conflicts, competence, all of those things. Maybe what you do is you agree to represent a client for a day in the Volunteer Lawyer for the Day program, or you agree to, you know, represent a client to ghostwrite a pleading for the client. But you're a nice person and you want to help, and you give the client your contact information so that if there's any follow-up, they can contact you. And then the client starts to call you from time to time with just a quick question about a parking ticket she got, or, you know, a question about a family law issue that's unrelated to, you know, whatever you were doing in Volunteer Lawyer for the Day. And the next thing you know, you have a relationship with this client where, from the client's perspective, you're her lawyer. You're the person she calls when she has a legal problem. And if it's not spelled out in writing, and it isn't made clear in some kind of retainer agreement, attorney-client relationships can be implied from action. And so a lawyer can end up with a lot more than what he or she bargained for. And so the way around, this one's actually not in the rules of professional conduct, that's more in state law and in the restatement of the law governing lawyers, where you get the decisions and the guidance that say that you can wind up with an attorney-client relationship you didn't intend on having. I mean, the other consequence of having such a relationship is that, in theory, the client could sue you for malpractice. You know, the first criteria of a malpractice case is that there has to be an attorney-client relationship. So there may be situations where you want to avoid the full-on attorney-client representation. And the way to do that, you know, with pro bono programs, you just want to stick to the parameters of the program that you're working for. You know, if there's a signed written statement that the program has with its clients, and that statement says that you're not going to be giving out your personal information and that the client, you know, isn't supposed to be contacting you after the program, then as much as you might want to be helpful and your instinct might be to be kind, you're actually better off sticking with whatever that arrangement is, or coming up with some new arrangement that, you know, you go into with your eyes wide open. Maybe you agree to take on another limited representation of that client and you have an engagement agreement. But just sort of letting things happen is a problem for lawyers. And then the other thing is that if you don't mind having an attorney-client relationship, you can still limit the scope of it. I mean, you just have to work out with the client in advance and make sure the client understands what you will do, but even more importantly, you know, what you won't do. If questions come up regarding taxes, I can't give tax advice, and I understand that you will rely on your tax counsel, so-and-so, for those questions. That kind of clause in a retainer agreement is a great way to help limit the scope of what you're doing in a way that doesn't harm the client and makes your obligations clear.
Great.
Okay.
All right. Thank you, Katie.
You're welcome. Thank you.